Good morning, everyone. I'm Andrew Singer, and I'm pleased to be able to chair this seminar entitled "What a Nuisance?" with 2 question marks. We've got 3 excellent speakers, members of chambers, who are going to talk to you about their take from their particular angles on 2 important decisions in the law of nuisance. The first is the decision of the Supreme Court in the Tate Gallery Viewing case. And the second is the decision of the Supreme Court in the Japanese knotweed case, Davis against Bridgend. Our 3 speakers are Stephanie Hall, who's a member of the King's Chambers Property and Public Law team, Wilson Horne, who is a member of the Business and Property team, but in particular has interest in all aspects of property transactions, and Jonathan Ward, who's another member of the Business and Property team, but whose main interest is in construction law. We thought it would be helpful to examine these cases by reference to those 3 areas, because quite often cases give rise to issues which affect more than one aspect of our practices and hence of our clients' interests. So all I'm going to say now is, in allowing Stephanie to take centre stage, is if there are any questions, I'll be monitoring those and try and put as many through as possible at the end of this, the speaking by our 3 speakers. Stephanie's going to speak first on the Tate Gallery case, followed by Wilson, and then Jonathan's going to speak about the knotweed case, again followed by Wilson, and we should have about 10 or 15 minutes at the end for questions. So without any more, I'll ask Stephanie to talk about the Tate Gallery case. Thank you.
Thanks very much, Andrew. So hi, I'm Stephanie. I'm going to do that awkward bit where I try and share my screen now and hope that I don't disclose all of my emails to just 300 people in this room. So hopefully now you can see some slides, and what you can't see is all of my desktop. So good morning. Yes, my name is Stephanie. I'm a member of the King's Chambers planning team. So I'm a public lawyer. So this is, I suppose, in one sense, an odd choice of case for me, because it's a private law nuisance case. But those that have already had a little dip into it will realise that there are some crucial paragraphs in there which expressly deal with the implications of that judgment for planning. And I suppose, as standing back, given that it's about 2 tall buildings in London, it's a bit of oddity that it's not a planning case. It is actually a private law case. But it does have some implications for planners, which is why is what I'm going to cover this morning. So just some background facts to bring us all up to speed. In 2016, the Tate Gallery on the South Bank in London opened a new extension. And that extension is 10 stories in height and had at its very top a viewing platform which expressly offered panoramic views across the Thames and around London. And the Tate made a big deal of it, invited lots of people, and I think there were some estimates discussed in the case about how many people came to look at London from the Tate Gallery Viewing Platform. And it was 5.5 million a year came to the Thames, came to the Tate, of which about half to 60% visited the Tate Gallery Viewing Platform. And from there, the problem was that not only were they afforded views of the whole of London, they were afforded views into the next door building. So the claimants all lived in the building next door, which was about, I think, at its closest point, 34 metres away from the Tate viewing platform. And those flats were obviously sold with also on the promise of express promise of panoramic views across London. And they had floor-to-ceiling glass windows. And the claimants lived broadly at the same height as the viewing platform, although they ranged from about the 13th to the 21st floor. And there were the people sort of in the middle of that range that were the most affected, because there were direct views across a 34-metre gap from the Tate Gallery Viewing Platform into their bedroom windows, essentially. And I think that there's one point in the judgment where the court records that it is something like living in a zoo, because of the sheer number of people that were afforded views into these people's houses, and that they were just living their lives on display for the whole of the day. So the viewing platform was open from quite early in the morning and sometimes quite late at night, and open also for private functions and things in the evening. So it was just kind of unrelenting stream of people looking into their living rooms and bedrooms, frankly. So kind of unsurprisingly, the claimants were a bit aggrieved about this, and they sought an injunction requiring the Tate to prevent its visitors from viewing their flats. So they asked for a kind of a mandatory injunction to stop the Tate Gallery allowing people into that viewing platform, or to erect something to kind of shield that sound, or alternatively damages. Now, the Supreme Court doesn't deal with remedy, so we can kind of park that for future enjoyment, because it's been remitted back to the High Court to deal with remedy. So we don't get to find out yet exactly who's going to be asked to do what. But the claims were based on the common law of nuisance, and they lost in both the High Court and the Court of Appeal. But they were absolutely persistent, and they lost for different reasons, actually, in the High Court and the Court of Appeal. But nevertheless, they lost. Yet they obtained permission to go all the way to the Supreme Court and argue it again. And by the slimmest of margins, a 3-2 majority, the Supreme Court allowed the appeal, and the claimants finally had some success. Now, I'm going to focus on the majority judgment, because whilst there is a minority judgment, it's sort of practical application. It is of academic interest, but it's not a practical application given the majority judgment. So they won because the 3 majority Supreme Court justices decided that, and the brackets are references to paragraph numbers in the judgment should you wish to go and have a read. It's quite long. An ordinary person, they said, would consider the level of intrusion to be a substantial interference with the ordinary enjoyment of their home. And standing back, that has to be right, yes, that if you are having your home described as living in a zoo, and it sounds like a level of interference that absolutely nobody wants at all. So just on a common sense matter, that sounds fair enough to me, really. I don't want people looking in my bedroom windows, thank you. And moreover, that inviting members of the public to use a viewing platform went beyond what was described as an ordinary use of land. And that was really the critical point of the judgment, that what was an ordinary use of land or not. And they said, well, even in the context of an art museum in central London, he was really the invitation to kind of come and have a look at this view, and the sheer number of people that was open to. The members of the public just come on in, have a look. Here are these people's bedrooms. And that was really the gist of it in the Supreme Court, that particular sequence of use just went beyond what was reasonable and ordinary in the circumstances. So they said, well, adding those two things together, an ordinary person would consider the intrusion a substantial interference, check, plus not an ordinary use of land, check, equals liable in nuisance. And the Supreme Court, although the judgment's very long, actually, they're really at pains to say, well, this is just an application of very standard principles. It's just A plus B equals C. We think that it's a substantial interference. We think that what the Tate is doing is not an ordinary use, equals nuisance. And they say, well, we just don't agree with the points made in the High Court and the Court of Appeal that, they both thought for different points that it was an ordinary use, or that the claimants should really have done more to protect themselves, and that was rejected by the Supreme Court. And I think it was the High Court that said, well, it wasn't. I think it was the Court of Appeal that said, well, actually, per se, overlooking can't be a nuisance, and that was also rejected. So the Supreme Court's done away with all that. They said there's nothing unusual really other than the facts here. Very ordinary principles leads you to a finding that they're liable. So there are 2 particular paragraphs in the majority judgment that give particular regard, and the headline is a bold heading in the judgment saying planning law. So obviously my eyes went straight there, and it's important because in the Court of Appeal, the Court of Appeal had considered whether there was a role for the planning system in avoiding this happening in the first place, and the Supreme Court expressly rejected that. So they expressly rejected at paragraph 109 that planning was the right point in time and the right tool to police what they described as inappropriate overlooking. And they said there's a real hard and fast distinction between private uses of land and what's an acceptable development of land in the public interest. So there's a completely two different streams. Nuisance of planning, they aren't going to cross over, and as planners we don't need to worry too much. And in fact, the phrase "the legal irrelevance of planning permission" was used, and it was just completely irrelevant in the nuisance claim that both of those uses had been granted planning permission. So we're not useful there, and that has to make sense, I think. So the 3 points on this slide are really, well, because even if a building would cause unacceptable overlooking, when you're determining a planning application, well, that's one harm. That might be one policy conflict. But that's not the whole balance, right? And it's completely open to you as a planning authority decision maker, or fighting a case in front of the inspector on appeal to say, well, that's outweighed by all of the benefits of the scheme, and here are those benefits. So because planning is more of a balance between factors, and some of which may pull in one direction and some of which may pull in another, you can never be said that the role of the planning system is to always, in every circumstance, expressly prevent any overlooking. That's just not its job, because it's all about balancing different interests. And also, just as a matter of practicality, the planning authority just isn't in a position to determine private law rights. The planning authority can't sit there and say, oh, yes, well, I think this could be liable to an injunction because of overlooking. I think that does meet a threshold of nuisance, so I'm not going to permit it. That's just not, it's not within the skill set of most planning authorities. So it wouldn't be fair to put that burden on them. There is also, I think, likely to be a distinction between standard kind of overlooking, I can see somebody's back garden from my bedroom window, to the scale and the nature of overlooking that was present in this case. The Supreme Court was very clear that this was of a kind of wholly unusual scale. So I don't think it's the case that planners should be worried that this case means that for kind of standard overlooking cases, back-to-back distances in residential development, that, this has any implications of that, because I just think that would be stretching it too far. But maybe there are some points to take away from it, maybe earlier in the process even. So, for example, when we are at a very early stage acting for developer clients looking at design, is it part of a planner's role to have a look at whether design can prevent those issues in the first place? Can you design in more privacy, kind of more privacy glass and things like that? Can you have a mind to that when designing buildings? And also, I raise a question about deliverability. So there are some particular policies which require the decision maker to have a look at the deliverability of the scheme. And also, I suppose it could be relevant as a material consideration, even if not expressly required by policy. But there are policies that require this to be considered. And if development could be shown to be undeliverable because of possible private law nuisance rights, which may lead to an injunction, could that mean that you breach that policy because you can't demonstrate that your scheme is deliverable? So there is a question mark there. But again, I think the better view is that it comes back to the point on the previous slide. Planning authority is just not in a position to determine private law rights. I think it's only right, coming to the end of my time slot, that I say that I think there are articles out there where other people take a different view and think that this case may have profound implications for planning. So there is some debate, but I'm afraid I disagree. And on that note, thank you very much for listening to me. And I think there's going to be questions at the end if you have any.
Thank you, Stephanie. I've obviously looked at it from the view of my practice, And if I can say one thing, or if I can recommend you do one thing in terms of the Fern versus Tate Gallery Authority, that is actually to read paragraphs 9 to 47 of the majority judgment. What it does, it very clearly sets out the legal principles in relation to private nuisance. And it's a very good, almost user-friendly summary. I'd just like to touch on or give a brief summary of the fundamental principles, but I may as well give away the punchline in terms of why liability was established in this case. I mean, is erecting a viewing platform so extreme per se, whereby developers potentially have, real problems in the future? Or was it really a question of the particular facts of this case? I'm bound to say the more I look at it, I think the fundamental point in the case was the highly uncommon and unusual use of the Tate viewing platform. And that, in essence, is the cornerstone in terms of the finding of liability. I mean, as Stephanie's indicated, it's been remitted back to the High Court to determine what remedy should be granted. And what is clear is that there will be a bun fight over that as well, because we're talking about obviously a very well-known museum on the one gallery on the one hand, as against and as I understand it, the claimant's apartments were very expensive indeed, and it may well be a case which doesn't arguably result in an injunction. Anyway, coming back to the principles surrounding private nuisance, there are 8 really to consider. The first principle the court tackles is the scope of private nuisance, and it's in essence what it's seeking to protect is the interest of the person with exclusive possession to use and enjoy the land. So that immediately cuts down the potential parties that could rely upon the tort of nuisance. And in essence, it's seeking to protect any diminution in utility or amenity value in terms of the property, and not necessarily personal discomfort. Now, what is also clear in terms of the second principle clarified by the Supreme Court is nuisance can be caused by any means. Now, there was debate in the lower courts as to whether or not overlooking could amount to a nuisance. It's absolutely clear from this authority that anything potentially can amount to a nuisance, and certainly overlooking did in this case. So there's no conceptual limit to what can amount to a nuisance. So it could be tangible, and that very conveniently will lead us on to what Jonathan's got to say on the Davis case concerning knotweed, or it could be intangible. Those types of cases tend to be vibration and smell, where there is no physical invasion as such in relation to the demised, in relation to the relevant property. What is also clear in terms of any potential nuisance is the sight of something can amount to a nuisance. And that's in paragraph 15 of the judgment, dealing with the complainants looking on to a brothel in one authority and a sex shop in the other. Now, moving on to the third principle, and it's given the general heading, unreasonable interference. We need to be careful with the way we use concepts such as reasonable user or unreasonable user. And in essence, I think it's best summarized in this manner. Unreasonable interference is just another way of saying interference is unlawful or to give rise to liability, an activity must unduly interfere with a person's use or enjoyment with land. And there's a very good explanation of this concept provided in paragraph 15 of the majority judgment that I won't read out, but I just add caution in terms of lawyers banding around in a ill-considered manner the concept of unreasonable user. So moving on to the fourth principle, the interference must be substantial. Put another way, it can't be minor, and the test is objective. There's probably not much more to say on that, save for on the facts of the Tate case. It was truly substantial. Stephanie cited the number of visitors using the viewing gallery, and it was quite astonishing, the numbers. Moving on to the fifth principle, and in my opinion, this is the absolute cornerstone of the Supreme Court decision. And this is why I don't think ultimately the decision is going to open floodgates. And that's the ordinary use of land. Now, what's fundamental to the common law is the priority accorded to the general ordinary use of land over more particular, uncommon or unusual uses. As the Supreme Court found in this case, this particular viewing gallery in this particular position was an unreasonable use of the land, given the opportunity it gave to numerous visitors to look in to the neighbours' properties. And the facts went to this level. There were even pictures of the inside of people's apartments being posted on social media and comments about the decor. So one can see that in terms of the Tate Authority, the facts are really quite striking. In terms of considering the ordinary use of land, in the judgment of the majority, it considers a very old case called Ball versus Ray. And in terms of the unusual use in that authority, what it was the conversion of a residential house in a residential area into a stable on the ground floor. Now, that's a 19th century case, and obviously, times change. But there, the principle still holds good to this day. It's what is within the locality. Are we dealing with an uncommon or unusual use? Just on this topic, there is a qualification where an occupier can't complain if the use interfered with is not an ordinary use. And this related to a case where the damage was caused to materials stored on the first floor, and the damage was caused by heat emanating from the ground floor. Now, what was being stored on the first floor was was paper that was very sensitive to temperature changes, so the paper was all damaged. Now, there was no finding of liability because that special use of the first floor was not allowed to increase the neighbour's liability, as it were. Now, ultimately, in terms of ordinary use, the rules of give and take and live and let live between neighbours apply, and this results from the ordinary use of land. There's a useful case called Southwark London Borough Council versus Tanner, and it deals with the give and take between residential tenants in an apartment block, and it's a good example of really what people have to put up with. Now, just to qualify the shorthand use of reasonable user, because in my opinion it's bad shorthand. It's not just a straight question of reasonableness. It's whether or not you're dealing with the ordinary use of land and it's done in a convenient manner. By that I mean not in an inconvenient manner. And the full description of this principle is set out in the Bamford and Turnley Authority Considered Act, paragraph 29 of the judgment. It's also useful to mention the Barr and Biffa Waste case that was considered also by the Supreme Court, and that was a smell case. And what was interesting, the smell emanated from a landfill site, but not all of the claimants succeeded, only some did. And what I take from that case was the description the court used. It qualified reasonable user. It said whether or not the use was reasonable in all of the circumstances of the case. Just moving on to the next principle the Supreme Court considered, it was reciprocity, and that deals with the give and take principle, and it is founded on the principle that the common law will always give priority to the common and ordinary use of land over a special and unusual use. And I emphasise that was the finding in this case in terms of the viewing gallery. It was a special and unusual use. Just moving on to the next principle, the freedom to build, and fundamentally there is, and that's where planning control comes in to restrict development. And obviously, proprietary rights are utterly irrelevant to the planning system. You tick the box saying you either own or whatever your interest is thereafter. Proprietary rights are irrelevant. Under the freedom to build section of the judgment, it considers the Hunter and Canary Wharf case. And in essence, the principle I take from that is the interference with the use of the claimant's land caused by the mere presence of the building on the defendant's land could not give rise to a claim in private nuisance. This is why no claim lies for interference with a view or prospect. And obviously in that case, it related to television signals being interfered with by the construction of a building. Moving on to the sixth principle, the locality principle, the point can be put quite neatly. What is a nuisance in Belgrave Square would not necessarily be a nuisance in Bermondsey. Now, I can't claim to lay any specific knowledge to Bermondsey or Belgrave Square in fairness, but one can see the point. It is a nuisance it's very difficult to name a locality because I don't wish to offend anyone, but is a nuisance in Runcorn next to the ICI plant. Is that going to be judged in the same way to the comparable nuisance in the leafy village of Prestbury? I'll leave that for you to answer. The seventh point is coming to the nuisance. It's still no defence, and the eighth point relates to public interest, and ultimately that is irrelevant too. But just to summarise, it provides a really good summary of the law. Does Tate make any difference to the law of nuisance? In my own opinion, it doesn't. They're very specific facts. And just to add finally to the point about considerations in relation to design, I think the ultimate issue for any designer will be whether or not the proposed development does actually amount to an uncommon or unusual use of land, because I think that's the benchmark in assessing whether or not it will ultimately amount to a nuisance. Thank you.
So from the Tate Gallery to perhaps what some may see as a slightly less glamorous case about Japanese knotweed, I'm going to speak about the Court of Appeal's decision in Davis and Bridgend, and in particular about the type of damages that might be recoverable in claims in nuisance, and when claims for diminution in value may succeed. So this is a case about Japanese knotweed. We know that knotweed can lead to significant issues when land is bought and sold and can affect property values. And this case examines the circumstances in which a claimant can recover diminution in value of their property from a neighbour who has allowed knotweed to proliferate. And although the case is about knotweed, it does highlight, in my view, the fundamental aspects of nuisance and makes us think carefully about what must be established in relation to damage in particular, both as an element of the cause of action of nuisance and in terms of recoverable loss. So it will be of interest to construction and commercial lawyers more generally, who are often involved in nuisance actions more generally, as some of us are. So I'll begin with a summary of the facts in the Davis case. Mr. Davis owned a property which adjoined land belonging to the local council. The council had allowed Japanese knotweed to proliferate on its land, and the knotweed spread to Mr. Davis's land. So Mr. Davis sued the council, claiming damages in nuisance. The case was tried by the district judge, and the district judge held that the council was liable in nuisance, but the claim being for diminution in value resulting from the knotweed, the district judge held that that aspect of the claim failed, which led Mr. Davis then to appeal to the circuit judge. Now, the circuit judge sought to apply an earlier Court of Appeal case, which also concerned knotweed, a case called Williams and Network Rail. And I've set out on the slide probably the most important aspect of the judgment so far as damages is concerned. So the circuit judge said, the only actual damage in this case, which is not physical, is diminution in value. However, I consider Williams's authority that such economic damage is not recoverable. The phrase, side note, this is a quote from Williams, the purpose of the tort of nuisance is not to protect the value of property as an investment or a financial asset, could not be clearer. I accept counsel for the appellant's argument that this is damage leading to a loss which is consequential on the nuisance found. However, it is not recoverable damage, it is pure economic loss. So just to recap, there was encroachment of knotweed onto the claimant's land, there was consequential diminution in value. The judge says that the damage is diminution in the value of the claimant's property. He says that there is damage which has led to a loss, but he says that the damage is pure economic loss and therefore not recoverable. Now, I think it's fair to say that a few things went wrong in this passage, but before we examine that in any detail, I think we should remind ourselves what we mean by pure economic loss. It's a phrase which we often come across in the construction sphere, for sure. And I think a good starting point is actually a negligence case called Spartan Steel. The citation is set out on the slide. Now, that was a negligence case, not a nuisance case. It was a case in which contractors, I think working in the road, damaged an electric cable. That caused a nearby factory to be cut off from the electricity grid. There were some materials in the course of fabrication in a furnace or similar, and those materials were physically damaged as a result of the furnace being shut down. Aside from that, there was a general loss of production because they couldn't operate the factory without electricity. And the loss of the value of the material, which was in the course of fabrication, was economic loss consequent on physical damage. That was recoverable. However, the loss of production, the loss of profit caused by the loss of production, was classified as pure economic loss because that, in contrast, wasn't directly consequent upon physical damage. And the Court of Appeal explained in that case, in Spartan, that the non-recoverability of pure economic loss is essentially a policy decision not to permit claims of that nature. And we heard the phrase floodgates earlier, and that's really what lies behind it. And this was also mentioned in the Davis case in the Court of Appeal, as we'll see in a moment. Because basically the class of claimants is going to be very extensive if pure economic loss is recoverable. But for present purposes, remember that if the economic loss is caused by physical damage, it is still economic loss, but it's not pure economic loss for these purposes. So getting back to the Davis case, what led the circuit judge to characterize the diminution in value as pure economic rather than consequential economic loss? As we will see from the Court of Appeal judgment, it was because of a misunderstanding of the earlier Court of Appeal decision in Williams, from which he quoted. So just briefly on the facts of Williams. It was another case about knotweed, but it had a slightly different aspects to Davis. It had two aspects, in fact. The first aspect was that there was knotweed on a defendant's land which had encroached onto the claimant's land. So in that respect, it was similar to Davis. But there was a second aspect. There was a claim in respect of knotweed which hadn't encroached on the claimant's land, but instead was confined to the defendant's land. So the claim on that basis was that because there is knotweed in proximity to the claimant's land, a diminution in value had been suffered, property had been devalued, but the Court of Appeal decided that on that second basis, economic loss caused by concerns over the proximity of knotweed didn't constitute damage for the purposes of a claim in nuisance, i.e. it was pure economic loss. The Court of Appeal made some other interesting observations in relation to knotweed cases more generally. It described it as a pernicious weed, said that it caused an immediate burden once it encroached onto a claimant's land, and that it was a natural hazard. It said it interfered with the amenity value of the land. So what can be taken from that is that there was no requirement to prove any additional physical damage beyond the fact of encroachment itself. If it hasn't encroached, then you're not going to have a claim. If it has encroached, you don't have to prove any physical damage beyond the encroachment itself. So I think from this we can start to see where the circuit judge in Davis went a bit wrong, because he didn't recognise that the presence of knotweed on Mr. Davis's land, which had encroached from the defendant's land, constituted damage in and of itself. In fact, he said that there was no physical damage, contrary to what was said in Williams. And the failure to recognise that damage, the encroachment damage, led the circuit judge to conclude that the diminution in value was not consequent on physical loss, and was therefore pure economic loss. So, put another way, he simply applied the wrong limit of the decision in Williams, because indeed, in the Williams case, damages for diminution in value were awarded. So let's look then at the judgment of the Court of Appeal in Davis. Just to take one paragraph, they said as follows: the ratio of Williams here is that there is no actionable nuisance caused by knotweed on a defendant's land simply because it diminishes the market value of the claimant's land. The reason why not is a policy reason which characterizes such a claim as one of pure economic loss. That phrase does not mean that in a case in which the elements of the tort of nuisance are satisfied, the claimant cannot recover for damage to their economic interests. And so in Davis, the Court of Appeal allowed the appeal. So I think as Wilson said about the Tate case, the Court of Appeal's decision in Davis isn't really notable for breaking new ground or establishing new principles. It's an application of existing principles, and it's really just correcting an error made by the misapplication of an earlier Court of Appeal decision, i.e. the one in Williams. And that error in applying Williams was firstly failing to recognise that encroachment by knotweed represented a physical interference which constituted a nuisance in itself. And secondly, and as a result of the first error, characterising the diminution in value as pure economic loss rather than economic loss consequent upon physical interference. So some concluding thoughts in relation to the Davis decision. Firstly, to establish nuisance, we're reminded that damage must be shown. But that formulation, that damage is an essential element of a cause of action in nuisance, is somewhat or can be problematic if we're not very precise about what we mean by damage in this context. And if you look at paragraph 22 of the Court of Appeal's judgment in Davis, there's some useful discussion of that concept. So what do we mean by damage for the purposes of a cause of action nuisance? Well, physical damage obviously counts, and physical damage will be presumed in a case of encroachment. Loss of amenity, which you may not immediately think of as physical damage, does count as damage for the purposes of constituting a cause of action in nuisance. However, and this is really the central point in Williams and in Davis, economic loss in and of itself is not damage for this purpose, i.e. for the purpose of establishing the cause of action in nuisance. That said, if nuisance is established by reference to qualifying damage without reference to economic loss, then consequential economic loss, e.g. diminution in value of property, is recoverable. So the lesson from these cases is that we have to be very careful about conflating the damage representing the nuisance and the damage caused by the nuisance. They may be the same thing in some cases, they may not, but it's important to separate them out to establish whether there is actually a cause of action in the first place. Some types of damage just cannot in themselves constitute nuisance, for example, diminution in value. But if qualifying damage is present, for example, loss of amenity or physical damage, then the next question is what other damage has been caused by the nuisance? So on that basis, diminution in value would be recoverable. And interestingly, it seems that even if the diminution in value is out of all proportion to the actual loss of amenity or physical damage, it will be recoverable, which really illustrates that this is a policy decision which limits the class of claimants so that some direct interference must be shown before diminution in value is recoverable. And I've just set out here some practical takeaways. Recall that in all of this, obviously, you need to show an actual nuisance, not merely encroachment. And I haven't gone into discuss the concept of unreasonable user as Wilson touched upon. But if assuming that is shown, the takeaway from the Davis decision seems to be the following. If you actually have an encroachment onto your land of knotweed or something similar, damages are probably going to be available, including damages for diminution in value. Conversely, if the knotweed is confined to the defendant's land, then whether or not its presence causes a diminution in value to the claimant's property, nuisance is not going to be established on that basis alone. And that's all I was going to say about the Davis case. Thank you very much.
Thanks, Jonathan. That's an extremely helpful summary. I completely agree with your point of view that effectively Williams has been misapplied, and that's what the Court of Appeal make absolutely clear. In comparison to the Tate case, we're dealing with a fundamentally different type of nuisance, in that assuming there is encroachment by knotweed onto the defendant's land, and it's more than de minimis, and that was one of the points made very clear by the Court of Appeal and the Davis Authority. Effectively, you will establish liability. The reason I say that is if one goes back to the very well set out principles in the Tate Authority, we need to remind ourselves of what private nuisance is protecting. It protects diminution in utility and amenity value, not personal discomfort. So let's assume the presence of knotweed on the claimant's land, and it's a presence that's more than de minimis. You can see it is quite obvious what consequences there may be. Prima facie, it's going to restrict your ability, for example, to develop due to the presence of knotweed. And what that will do is increase the development costs, because obviously you'll need to kill it and remove it in order to build in that area. So when one bears what private nuisance is protecting, utility and amenity value, a more than de minimis presence of knotweed, you can see why you will effectively assume damage. It may be less glamorous knotweed than a viewing gallery in the Tate Gallery, but in the real world, it's highly significant. The presence of knotweed. What does flow from the Davis judgment is that knotweed close to the boundary, but not having grown, as it were, onto the claimant's land, that there won't be any nuisance at that point. What you will have is an apprehended nuisance, and that takes us into the remit of the court granting Kaya Temet injunctions when there is an apprehended nuisance, and it's appropriate for the court to restrain that nuisance. So that's worthy of mention. But in terms of where the Davis case takes us on the development of principles in private nuisance, other than explaining Williams, in my opinion, it doesn't take us anywhere. It just clarifies what was unclear before. And returning to the Tate Authority, I said at the beginning of my sweeping up talk to Stephanie's very helpful talk about recommending to today's attendees that you read paragraphs 9 to 48 of the majority judgment. And now I've heard Jonathan's talk, I can absolutely recommend that you do that, because it's the best and most concise statement of the relevant principles. I've obviously read Davies in detail, and whilst there is a useful summary of the principles, it's nowhere near in the same detail as the Tate Authority. So if you take anything from today's webinar, do that reading. Thank you very much.
Thank you very much to all of our panelists. And we've had a few questions on the Q&A and also a few questions on the chat. I'm going to try and deal with a couple of them. First of all, I think there's a couple of questions for Stephanie. Is there now a reticence to have rooftops and viewing galleries in London in particular? In other words, has it generated more cases that you know of? Secondly, can't they just screen off the apartment? And also, is there any issue arising because you need planning permission to have a balcony?
Okay, well, I'll take those in order. So are there other cases that I'm aware of? Two points on that. Firstly, because the claimants lost in the High Court and the Court of Appeal, and their only sort of victory came on the 1st of February with the Supreme Court decision, it's probably too early to say yes to that. And secondly, I'm probably not the right person to ask, because I wouldn't be dealing with anything nuisance related, because I'm not a private lawyer. So no, I'm not aware of anything in the planning sphere. I'm aware of, obviously, it's caused some ripples amongst commentators, and so that there may be that may have practical knock-on effects, but it's probably too early to say, because the claimants only succeeded anywhere on the 1st of February. In terms of screening, this was considered actually in the Supreme Court decision and featured in the debate in the lower court, because obviously one or other of the parties could have fixed this by screening it, either by putting up some lovely net curtains in your riverside apartment or by erecting a screen on the Tate balcony. However, that really goes to the crux of the matter. The point was the complete conflict between the USP, essentially, of both the Tate Viewing Platform, which said, come to us, we've got panoramic views, and the swanky apartments, frankly, next door, that said, come and buy our swanky apartments, we've got panoramic views. And so if either of them was to budge from that, they would lose their unique selling point. The whole purpose of the way that either building was designed like that was to give panoramic views, and you'd be cutting down on that. So that might be where we go as a pragmatic solution, but it goes right to the heart of why there was a real kind of people really dug their heels into this dispute, because both of them wanted to maintain their panoramic views. So it was on you blink first, no you blink. Okay, so that's probably why there's no screening resolution. That might have been a mediated settlement, but wasn't what happened. In terms of planning permission, obviously it's a standard overlooking, even not going anywhere near the level of effect in this case, is something that would be taken into account by planning authorities when seeking permission for a building that had either panoramic windows or a balcony, and should be properly looked at based upon the state of affairs that exists at the time. The problem is obviously that one of them comes later. So it might have, at the point when the building with the residential apartments in it with the nice glass windows was given planning permission, there was no there was no balcony on the Tate. Then the Tate erected their extension with the 10th floor balcony. And so that came later. And it's something that would have been considered at the point of the grant of planning permission, but that's not a complete answer, because obviously the financial and other benefits that the Tate brings, that extension to the Tate could generate. I haven't gone back to read the planning authority's decision to grant planning permission for that extension, but I assume they just say, well, if there is an overlooking problem, then that's something that it is for the private law sphere, it's not for us. And they were entitled to do that to an extent, unless they were satisfied it was going to significantly adversely affect amenity, which I think it probably did in this case. But then they're also entitled to reach the view that significant effect might have been outweighed by the benefits. I mean, there presumably were significant benefits of extending what is a very prestigious, well-known, internationally renowned gallery. So it's a hard one for the planning authority, frankly. I hope that answers your questions, and thanks very much, Andrew.
Yeah, thank you very much, Stephanie. I think it does. The other question which is raised is for Jonathan, which is how the diminution in value was calculated in the Davis case, and whether it was treatment over a course of years that diminished the diminution in value.
Well, I think the first thing to say is that if you're looking for an explanation of how diminution in value damages are to be calculated, Davis probably isn't the place to start, because there was actually a respondent's notice point in relation to the calculation of damages. But it's important to bear in mind the claim here in this regard was under £5,000, and the point was the evidence wasn't of a very high quality. And the Court of Appeal basically said, well, it's the only evidence we have, and that's what we're going to award. But there are a few points which are made in kind of paragraphs 51 onwards, which raise some of the factors that will be considered. When is the diminution to be calculated? Is there a prospect of or intention to develop? Would the nuisance have ceased before the intention to sell arises? So there's an exposition of some of the relevant principles, but there isn't really a strong statement of how it's going to work. But I mean, the point to bear in mind is that if there is a claim for diminution in value, it has to be properly evidenced, probably by reference to expert evidence.
Okay, and then there's just an interesting, I think, potential curveball, which is, what do you think about using antisocial behaviour legislation to address the issue of knotweed on property? And I don't know if either you or Wilson have ever come across that in practice.
I haven't come across antisocial behaviour legislation. It's not something I would hold myself out as an expert in. I mean, if it amounts to, if there is encroachment, as we've seen, then it seems that the law of private nuisance is going to be of some assistance. I couldn't really say what prospects there would be of relying on antisocial behaviour legislation.
And then finally, and perhaps one for either you or, again, if Wilson wants to answer it, if there's an apprehended nuisance, so if there's a wall that might collapse, and so you have to close your business temporarily, but it doesn't actually collapse because they fix it, so there's no physical damage. There's loss, but there is loss of profit. Do you think that would be then recoverable on the basis of an apprehended physical damage case rather than an actual physical damage case?
Well, I think the first point is that whether or not damages are recoverable, there may be scope for an application for an injunction, which may be the first thing to think about in such a case. Whether or not damage is recoverable, well, on the basis of Davis and Williams, you might think that they're not, because unless there's been an encroachment, then arguably there hasn't been a damage for the purposes of nuisance. But that said, if there's an imminent physical threat of harm to the use of to people using the land, it may be that's considered unreasonable user, and there may therefore be claims for damages, including economic loss.
I think we're literally at our time now, and I realise that people have given up their morning. So thank you on behalf of everyone else. Thanks to all the panelists for their talks. The slides will be available afterwards and sent out to those who are attending. Thank you all for attending this King's Chambers seminar. We appreciate that you've got other important claims on your time, and we hope you've enjoyed it, and we hope you join us again for future seminars delivered by other members of this and other teams at King's. So wish you all a very good morning, and thank you all very much.